2.5 million documents. That number is not a typo. The United States Department of Justice, under Attorney General Pam Bondi, has been sitting on 2.5 million files and blocking every attempt by Congress to see them. A federal judge just changed that. And what the court unsealed on Wednesday is unlike anything we have seen from this DOJ before. I have been through the filing, all 847 pages, exhibits A through M, and what is buried inside this document is not a standard privilege dispute. It is something that raises fundamental questions about who this Justice Department is actually protecting and why. Let's start with the timeline, because timing is everything here. 14 months ago, the House Oversight Committee filed a formal discovery request. They wanted communications between DOJ officials and Trump Organization entities. Standard procedure happens all the time. What is not standard is total silence for nearly a year. January, the committee submits the request. April, DOJ acknowledges receipt and says they are reviewing scope. September, still reviewing. December, the committee files a motion to compel. This month, a federal judge unseals the government's response, and that is where the 2.5 million files enter this story. Here is the critical detail. The DOJ did not say these documents do not exist. They said something more revealing. They said the documents are subject to, quote, executive privilege considerations and ongoing classification review. Translation, we have them. We are not giving them to you. But the judge ordered a privilege log, a complete list of every document being withheld and the legal reason for each withholding. And that log is in the filing. Page 214, I pulled it myself, reads communications regarding financial transfers between Trump Organization subsidiary accounts and DOJ adjacent consulting entities, November 2024 through March 2025. That is not my characterization. That is the government's own language in a federal court filing. Think about what that means. The Department of Justice was receiving communications about money moving between Trump business entities and consultants connected to the DOJ during the presidential transition and after, and they are claiming privilege over all of it. Page 341, different section, a category labeled family member correspondence, privileged 47,000 documents in that category alone. Now here's where the picture sharpens. The privilege log shows a clear pattern. Communications with the Trump Organization flagged as privileged, over 180,000 files, documents involving Ivanka Trump's consulting firm categorized under national security review, Jared Kushner's Middle East investment correspondence marked under ongoing. Investigation protection, Eric Trump's real estate transactions listed under third-party privacy. Every document, every category, all withheld, all under Bondi's signature authority. But it is Exhibit K, page 673. That changes the entire story. There is a memo dated February 14th, 2025, 3 weeks after Bondi took office. Subject line, revised document retention protocol, special handling procedures. The memo establishes a new classification tier, not top secret, not confidential, something called EPS, Executive Protection Sensitive, a designation that does not appear anywhere in standard DOJ classification guidelines. They created it. And what falls under this invented category? According to the privilege log, all communications involving direct family members of current or former executive branch principals where disclosure could impact ongoing business relationships. Read that again slowly. Ongoing business relationships. That is not a national security standard. That is a commercial protection standard invented inside the DOJ within weeks of a new attorney general taking office. 2.1 million of the 2.5 million withheld documents fall under EPS. That is 84%. Now look at Exhibit L, internal DOJ emails about implementing the new protocol. One email from a career DOJ attorney, name redacted, to a supervisor, says this categorization has no statutory basis and recommends consultation with the Office of Legal Counsel before implementation. The supervisor's response direction comes from the AG's office, implement as written. That email is dated February 18th, 2025, 4 days after the memo. A career attorney raised a legal alarm. The response was, do it anyway. That is the structure. Now let's talk about the number that puts everything else in context. According to the privilege log descriptions alone, not the actual documents, just the category descriptions, the financial transfers referenced in those withheld files carry an aggregate transaction value of $1.7 billion. And Congress cannot see any of it. Then comes Exhibit M, the one most people stopped reading before they reached a whistleblower, a sworn declaration from a career DOJ employee, name redacted, identified only as someone with direct knowledge of document handling procedures. The declaration states that this employee raised concerns about the EPS classification to their supervisor in March 2025, was told to drop it, raised it again in June, was transferred to a different division, filed an internal complaint in September. That complaint went nowhere, and they contacted the Congressional Committee directly in January of this year. That is how this investigation started. Not political fishing, a whistleblower. And the declaration includes a direct quote. The whistleblower says came from inside the DOJ. Certain documents could not be produced because they contained information that would be, quote, embarrassing to the family, not harmful to national security, not damaging to executive deliberations. Embarrassing. Federal Judge Sandra Mitchell of the D.C. Circuit saw that allegation and responded immediately, ordering the DOJ to explain in writing whether the EPS classification was designed to protect embarrassment rather than legitimate privilege interests, with that response due Monday, March 24th. Now let's talk about what the experts are saying, because this is not a partisan debate. Former Deputy Attorney General Sally Yates, with 27 years at the DOJ, says creating classification categories outside established frameworks is, quote, highly irregular. She has never seen it done this way. Harry Littman, former U.S. attorney and constitutional law professor at UCLA, says the privilege log descriptions alone suggest business protection, not executive function protection. Even Jonathan Turley, who frequently defends executive authority, admits the embarrassment allegation in the whistleblower statement needs to be addressed directly. And Andrew Weissman, former FBI general counsel and Mueller prosecutor, said it plainly, 2.5 million documents under a made-up classification is not privilege. That is a wall. This is not a left versus right argument. It is a question about whether the chief law enforcement officer of the United States used her office to invent new legal tools to protect specific people from specific information becoming public. There is another dimension here that affects every taxpayer directly. Legal filings estimate the DOJ has spent $4.3 million in legal fees fighting this discovery request since April of last year. $4 million taxpayer dollars to keep these documents away from congressional oversight. And the precedent being set reaches beyond this case. If a federal agency can invent a classification category to shield information it describes internally as embarrassing, every future FOIA request, every future oversight investigation faces the same potential wall. Former administrative law attorney Catherine Powell put it this way: every new privilege category weakens the presumption of transparency. That affects everyone who ever wants government information. Here is where we are right now. Pam Bondi's own conduct is under a microscope that her history makes more uncomfortable. In 2013, her Florida Ag office was reviewing whether to join a lawsuit against Trump University. Trump's foundation then donated $25,000 to a PAC supporting Bondi's re-election campaign. And 4 days later, her office announced they would not join the lawsuit. No charges were ever filed, but the pattern was established. In 2024, during her confirmation hearing, Senator Amy Klobuchar asked directly whether she would recuse herself from matters involving the Trump family. Bondi's answer was that she would follow ethics guidance from the Office of Professional Responsibility, not yes, not no. She was confirmed 51-49. And now, weeks after taking office, she created a classification tier no one had ever seen before, applying it to 84% of documents requested by Congress. Documents that a career whistleblower says were withheld specifically because they would be embarrassing to the family. Thursday morning, Bondi held a press conference and called the filing a partisan attack. The committee chair responded within 2 hours, if it's lawful, produce the documents. By Thursday evening, an anonymous DOJ official told reporters that Bondi is personally reviewing which documents might be released under the court order. Personally. The Attorney General, whose potential conflicts of interest are the entire subject of this dispute, is personally deciding what gets disclosed. Ethics attorneys immediately flagged it, and the DOJ walked the statement back Friday morning, saying it was taken out of context. The damage was already done. Monday, March 24th is the date that matters. The DOJ's written response to Judge Mitchell is due. Either they provide a coherent legal basis for the Epps classification, or they cannot. If they cannot, Judge Mitchell can order immediate document production, which would trigger an appeal to the D.C. Circuit, potentially the Supreme Court or the DOJ folds, produces the documents, and we see what 84% of 2.5 million files actually contains. What is in those documents, no one outside Bondi's office currently knows, but the Attorney General's own choices. A made-up classification system, a $4 million legal fight, a whistleblower silenced internally for 10 months, and the decision to personally oversee disclosure tell a story of their own. Sometimes the cover is the evidence. Subscribe and turn on notifications. Monday's filing could change everything. I will break it down the moment it drops.